Get your letters out, people.
You lit a match in the tabloids, watch the fire spread fast. Two little lies in a cradle of glass. You painted halos on shadows, wrote lullabies for ghosts. But the elaborate scheme was conceived in your throat. You played your part like a movie queen, a silver screen lie in a magazine dream. You said they were real, but their points spin. Whispers made flesh, your tonsil twins. Your baby bump hit a pillow with it. Play it, pretend till the truth walked in. The spotlight fades and the lights grow dim. Now who's gonna hold your tonsil twins? Your script was a mouthful, too hard to conceal. You spat out your lines, but choked on the reveal. The truth was a burden you couldn't swallow down.
Yeah, it's deep.
And the stain of your tail splashed on your gown. It's hard to keep your story straight when the paper trail shows no due date. You said they were real, but they're born in your spin. Echoes and rumors, your tonsil twins. You dance on the edge just to reel them in. Your whole defense started to spin. Now all that remains is a stain on your chin. Nobody's buying your tonsil twins. Detectives knocked on the door one more, woke you up where the lie was born. Your load of lies, now a sticky mess. Every word you spoke is a stain to dress. You said they were real, but they're born in spin. The verdict comes down, you'll never win. Thirsty for fame and TV shows, you got left drinking from an empty hose. Now the truth's been shown and you're all alone, left all alone with your tonsil twins. Your tonsil twins. You're all alone with your tonsil twins.
CR 2025-007905. That is the supervision indictments. Can I get appearances, please?
Morning, Your Honor. Nicole Northup on behalf of Ed Leiter for the state.
Thank you.
Good morning, Your Honor. Jeffrey Swirsky appearing with Ms. Owens as to both matters. She is present in the courtroom.
Ms. Owens, can I get your name and date of birth, please?
Laura Owens, 5/14/1990.
All right, thank you.
Yeah, we know.
So on the older case, we're here for a status conference as Mr. Swirsky was appointed to represent Ms. Owens. There has been a supervening indictment filed. I provided a copy to Mr. Swirsky. Mr. Swirsky, did you have the opportunity to review that with your client?
Yes, I did, Your Honor.
Did you want me to conduct a not guilty arraignment today on her behalf?
Would, Your Honor.
All right. Do you waive a reading of the charges and her rights?
Yes, we will waive formal reading
Yeah, we'll waive it. She knows what she did.
and enter a plea of not guilty as to all charges.
All right. We'll enter a plea of not guilty on her behalf. I need to set release conditions in that the newer case is a defense request.
Actually, I don't know which defendant this is for, but I think it's just another round of charges for another defendant. I don't know if we're up to 2 or 3 now that she's actually been charged with. I know there are more.
The same release conditions that are
Yes,
in
Your Honor.
the,
First matter was OR, and I believe that this is just expanded a little bit, but nothing changed as far as anything that would warrant a change in the release.
all right. State have anything to contribute on that issue?
No.
All right, it is
Yes. Thank you.
OR release. So in the new matter, that I will release her in her own recognizance under the same terms and conditions as the 006831. As far as the new dates in that matter, there's going to be an initial pretrial conference on January 21st at 8:15 before Commissioner Popko, a comprehensive pretrial conference February 25th at 9 o'clock before me, final trial management conference April 16th at 9 o'clock before me, then trial assignment April 23rd at 9 o'clock before the trial assignment judge. That judge is located on the 5th floor of this building, courtroom 5B. Ms. Owens, you need to make all those court appearances. If you were to fail to appear, warrant would issue for your arrest. If you don't show up for your trial, it could occur in your absence. Stay in touch with your lawyer. Make sure he has a good cell phone number for you at all times. New last day in the new matter will be May 31st, 2026. Ms. Northrup, as to the 2025-006831, is the state moving to dismiss that matter at this point? Or are you going to be filing a written motion on that, or?
The state's going to be filing a written motion now that she's officially been arraigned.
All right. And Mr. Swirsky, when I get that pleading, can I just rule on the pleading?
Yes, Your Honor.
Okay. So
The only question I have, Your Honor, is do the new dates reflect this case being complex as well? I see that the other one had been designated complex. This is an expanded
it's
version
more,
of
it's
the
more
previous
complex.
one. So
I don't
it's
think,
more complex than the last.
I don't think it does. So give me, because it'd be 270 days after her arraignment date, which is today. All right. And is the state in agreement that this should be designated complex?
Yes.
All right. Makes sense since the previous one was. So I'm going to get you a new set of dates. Just give us a minute. Val, can you do that for me? Okay. So what was the new last day? August 29th. New last day will be August 29th. So we need a trial date, trial assignment 30 days before that. FTMC 1 week before that. And I think the IPTC and CPTC dates would remain the same, right?
Trial date would be July 29th at 9 a.m. and the FTMC would be July 22nd at 9 a.m.
Ma'am, are you a whore?
The trial dates will be the final trial management conference, July 22nd at 9, trial assignment, July 29th at 9. The initial pretrial conference and CPTC dates will remain the same. And let's see, that's 30. IPTCs are non-appearances still, right?
Typically, yeah.
Okay. Should we,
I would propose just changing the CPTC to a CCMC and start it off like that.
all right, is the state in agreement with that
Yes.
schedule? Okay, so instead of a CPTC, well, we'll just call it both, a CPTC and a CCMC will be February 25th at 9 o'clock. So that'll be the first time I will see you on the new version of this case. It's a couple of months out with the holidays and everything. If there's anything that you need before that, just let me know. I can get you back on the calendar. Mr. Swirsky, since I have you here, have you received disclosure?
Yes, in the last week, I have received approximately 6,000 pages of disclosure and 16 body cam recordings, all within like the last week from the state.
All right, so the state's been responsive to your
Yes.
needs in that area?
Very much so.
All right, well, if you need me to get involved in anything, just let me know. Like I said, and I will schedule something before February. Otherwise, we'll see you February 25th. Did you get all those dates, Ms. Owens?
I'll write them down and get them.
Okay, all right. Anything else you want to talk about?
No, Your Honor, thank you.
Anything else from the state?
No, Your Honor, thank you.
All right, thank you. We're in recess in this matter.
Well, there you have it. I mean, it's just some housekeeping, but it's kind of fun to watch all this play out. I see, for all the world, I see this shaping up as just get all the charges on file, do all this stuff. And the deal here, I'm guessing, because she doesn't have a big prior criminal record, the deal here is going to be you got to eat some convictions to avoid jail. That's my guess, but I'm not sure she'll do it. She might press this thing and get herself into prison, which is fine. It's what she deserves. But, I think we could fix it all like this right here.
She just needs an Italian sausage and a corn dog, and that would fix her right up.
Mr. Keith, he is on the calendar as number 6 and 7, and I'm standing in for Ms. Clark. It appears, I'm not actually sure from notes whether this has been filed. It does sound like she is going to file a 1077 order, but otherwise I just asked to keep dates.
Incorrect, Your Honor, if I may. I had actually asked her if she would withdraw because we weren't communicating very well, and I had asked her if I could, just make an arrangement so that I could file a plea with the court so that I could change my plea. There was a previous plea bargain on the table for 60 days in custody, and I told her that I would take that, and she wasn't in agreement with that, and I told her that I have a job and children waiting, and I need to hurry up and serve my time, and me and her just weren't communicating very well. So I made the decision that I would like to, file with the court while there's all parties present so that they can hear the situation, so that they have copies of the agreement, and I would like to verbally file a motion with the court to change my plea, and right now, currently, I would like to plead guilty to the charges so that I can move on.
And Mr. Keith, I don't think we're set up to make that happen right now.
Well, that's what I'm doing, ma'am. I've been waiting for 4 months to do that, so I apologize for
I like it. It's stupid and it's wrong. But I often use this argument myself when somebody objects in life to anything I'm doing. We can't do that right now. Yeah, well, that's what I'm doing.
what you want to do, but that's what I am doing.
And Mr. Keith, I'll make that decision on your request when you and Ms. Clark are present.
Okay, Mrs.
So,
Clark, I believe,
just-
has withdrawn from my
She is
attorney
not withdrawn from
position.
your case.
She hasn't. So Ms. Clark will get your case set onto the calendar if you want to enter a guilty plea or for any other reason. So we're going to hear from you again on this case on December 26th or sooner if you and Ms. Clark put the case on the calendar for a reason sooner, like changing plea, or if there's a need to change attorney.
Your Honor, if I may, I've been waiting for 2 months for today.
Okay.
Did you hear me?
I sure did, Mr. Keith.
Okay. I was under the impression that
Like, he's dumb. He doesn't understand the procedure. But if you take that out of it, just from a very basic sort of kindergarten level, what he's saying is rational. I've waited a long time. I want to end this now. Okay. Now's not the moment for it, but it makes sense.
today was my day in order to file that, because if not, then I would like to file a motion for the fact that on the grounds that they're violating my rights to a speedy day or a speedy trial within 60 days in custody, because
Stop talking about what you would like to do. Do it or don't.
I'm well past that. I'm at over 2 months today.
All right, Mr. Keith, you can file that motion and we'll consider it. And there isn't anything I can do today if
So
you
what
were
is it that
expecting
we
that.
want to do today, Your Honor?
Today's a pretrial hearing. Okay, your attorney, Ms. Moore, on your attorney's behalf, has alerted the court to some issues that are going to have to be decided in your case. You've done the same thing. That's what pretrial hearings are for. Now, feel free to file any motions that you believe are appropriate. And
What
we'll
about
deal
fact
with them.
finding? What happened to fact finding?
That's
An
your
arraignment.
trial. You may be referring to your trial. That'll
No,
happen.
I'm referring to fact finding and arraignment, Your Honor. This is my very first day of court in over 2 months.
All right, Mr. Keith, I don't know exactly what you're referring to, the
Fact
language
finding
that you're
hearing
using.
and my arraignment, Your Honor.
Okay, yeah, you were previously arraigned on all of these charges.
No, sir, I was not. I've been sitting in a box for over 2 months. I've been waiting for today specifically for my chance to tell you that I've been cooperative, I've been good, I've been trying, and I've been trying to tell them I need to get back to work. I need to get back to my children.
Mr. Keith, there isn't anything else that's going to happen today?
Just in time for the holiday season.
So the next hearing's in a couple weeks.
He said the 26th. That's in 4 weeks.
It's in 4 weeks. It's in twice a couple weeks.
Yeah, that's 9 weeks from the last time they told me that.
Okay.
So that brings it to 15 weeks, or excuse me, 14 weeks that I've been waiting for court. And I've never been,
Yeah, dude, sucks for you. File a motion.
I never had arraignment. I've never had fact finding. And if pretrial, if I still don't, I'd like to have copies of all discoveries, of all materials. You don't need to pause that. I'd like the judge to hear it, ma'am.
Right.
I'm requesting copies of all discoveries, of all information, of all charges that I'm being held on. I'm well aware of the dates and times that I've been sitting in solitary confinement and isolation on a concrete floor, Your Honor. There's nothing wrong with my cognitive thought processing. There's nothing wrong with my
There's a lot wrong with it. There is a lot wrong with it.
demeanor. There's nothing wrong with the situational circumstances of why I'm here other than the fact that they're not accurate and that I'm being held here on false charges. Now, the pretense that they have is that I committed crimes that I did not commit, and I'm aware of the situation. I'm aware of the process. But the fact is that while there is all parties present, I want to file a verbal motion to withdraw from the attorney. I want to fire my attorney because I very, 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 very clearly on 3 separate occasions told her I want something to happen, and she very, 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 very clearly did the opposite. Now, I want to file a affidavit of prejudice against her, and I want to file a conflict of interest against her. I apologize that I have...
An affidavit of prejudice. Here we go.
Not filed the motion with the court in paper. They do not allow this paper to be accessed by myself. I have to file this motion verbally while all parties are present, including the woman here standing next to me, or excuse me, sitting next to me, including the attorney sitting next to you.
The prosecutor's not there, so all parties aren't present. I mean, I don't. I didn't mean to deflate your balloon, but that's just those are the facts on the ground here.
In the courtroom, including the DA, including yourself, Your Honor. All parties are present, and the process, being due process, is being advised. I'm well aware of my rights, and I'm well aware that I am way past my right to a speedy trial within 60 days.
Mr. Keith, just stop right now, okay? Ms. Moore, when is Ms. Clark going to be available on this calendar?
I mean, I can check with her. You mean on the? Let me.
Yeah, on the in custody
Right now,
calendar.
Your Honor, she's standing outside the door.
I want to have Ms. Clark and Mr. Keith here in front of the court at the same time.
Yes.
She's here right now, Your Honor. I just spoke with her several minutes ago. She's currently right outside the door. I'm well aware of my surroundings, Your Honor. I'm well aware of my capabilities in this situation. I'm well aware of the situation, and I'm well aware of what you need. I apologize for my demeanor, but that's quite frustrating to me that somebody would say you have to sit there and suffer on a concrete floor another 2 months because somebody said something I asked them not to do. And I'm also aware that I won't get another chance to be in front of you because they will file what I asked them not to, when previously me and you had this conversation when I told you this previously and you said that you wouldn't do that. And I'm also aware that they're going to try and do it anyways. And I'm also aware that the person sitting next to me has had a conversation with them without my will. And I'm also aware that this person was fired. And I've also told them that there's a conflict of interest. And I've also told them that there's an affidavit of prejudice against them with the court. Now, if they have removed that paperwork, I want to file suit against them. And at this current time, I'm letting the court know that I'm filing a verbal motion with the court that I will file suit against them if you do not receive that paperwork within 24 hours.
So Your Honor.
Now, ma'am, I will speak for myself. You have been fired.
So,
you
Mr.
do not
Keith-
represent me, ma'am. I can speak for myself. Thank
Mr.
you.
Keith, the judge asked me a question. I'm trying to answer it. So, Your Honor, Ms. Clark is not at the jail right now. She will be handling county matters on, I believe, the 19th, but I'm guessing could be available before then.
Your Honor, if
Yeah,
I may,
I
that's not
wanna get-
indirect. I can tell you the exact
Mr.
suit
Keith,
she's wearing
please
right
stop.
now.
All right, just, Mr. Keith, step out of the booth. Go with the correct.
He's doing awesome for all the law students. I get a lot of law students that watch the channel. Yeah, just emulate everything this guy's doing. You're going to be awesome. You're going to have a great career. Just act like that all that you can. Just watch it again and again. It's brilliant.
Officer.
Yes, sir. I apologize for being upset. I apologize for my demeanor. I'm just trying to express to you the certainty and
Okay.
specifics of my situation.
So,
I'm
Mr.
trying to get
Keith,
to my children.
You've
and
done
my
that.
job,
You're
and
just,
to
you're not
hinder
letting
that.
anything else happen.
I understand.
I'm going to reset this case for soon in the next couple of days so that Ms. Clark can be present before the court with Mr. Keith. We can sort out the issues of representation, whether he's going to or not. And I heard there was potentially going to be a request for a competency evaluation. We'll evaluate that request as well. And we'll go from there. But it doesn't look to me like a lot of progress has been made on this case, and I want to get that done.
Absolutely, Your Honor.
Hear you guys.
Oh, now you can. Okay, good. Good. And I can hear you as well. All right. So we are ready to proceed. Both parties are present.
Okay, that was Zach's fault over at LawNerdsUnite, and so is this. I haven't seen it, but we're starting strong. Starting strong with the nose ring.
We have Ms. Henry, our clerk. We're recording this matter using Zoom technology, which is how we're handling this hearing today without objection. Ma'am, am I pronouncing your name correctly? Is it McCunick?
That's right.
Okay, very good. As I indicated, this is a motion that's been filed by the defense, Mr. Wilkins. Mr. Wilkins is challenging the issuance of a personal protection order in this case. The order was issued by the court as an ex parte order. It does allow, obviously, for appellate opportunities. In fact, it's not really even an appeal. It's a hearing on the initial order, and that's why we're here today. Let's go ahead and I have some presentation of evidence. We're going to start with the movement. That's you, Mr. Wilkins. I have read your material. And let me just lay the foundation for you a little bit here so you know exactly what to address.
Yes, sir.
It appears to me, having reviewed your comments and also reviewing the plaintiff's filing, it appears to me that she's made it clear that there is to be no contact whatsoever. If that happens with someone, it doesn't matter who it is, and you continue to try to smooth things over, resolve the relationship one way or the other to your satisfaction, that can be considered to be harassing behavior. Multiple harassing events are sufficient in order to create an opportunity for issuance of a personal protection order, which is what we had here, at least based on the initial information that was provided. So what I'm going to want you to do is discuss, and you really didn't get into this in your materials, discuss with me your contacts with her, whether those contacts occurred after she had made it clear that she did not want to have contact with you. And we can go from there. Okay. So if you please raise your right hand.
Of course.
We swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
So help me God.
All right. Mr. Wilkins, what would you like me to know?
Well, from the beginning, Alexis had been cutting my hair for a little bit over a year. During a time when the VA had initially dropped the ball on my care. I met legitimately with Jack Bergman face to face in his office. After that meeting, I had a haircut with Alexis. I had tried to get it scheduled beforehand, so I didn't look like an extra from Duck Dynasty at the time. I had big old nasty beard. Regardless, I was, I wouldn't say fired up, but I was on the topic of my meeting with Mr. Bergman, which was the VA and their care. And it was, just talked about my core values there, which include, no parent should ever bury their kid and, stuff like that. Fast forward a little bit of time, she had cut my hair a few more times, had showed interest, in which I had, had asked for her phone number. And again, the way that I asked was, she mentioned she had a boyfriend. I said, hey, is it okay if I'm, a little bit forward? To which she said yes, and said, when I say you do badass things, what I mean is I think you're a badass. I would love to get your phone number. She gave me her phone number willingly. And, I had hair. And when I got home,
Oh, the cringe. Oh, it hurts.
Immediately messaged my buddy from the military and said, hey, this went well. What should I say? And I ran, my initial text message by him, which was, hey, your packages are, those spam text messages for USPS. Your USPS package has arrived at where ... Just kidding. It's Zach. Here's my phone number. If you want to grab a coffee this week, let me know. To which I got a response of, my boyfriend was right. I should have never given.
Oh, God. He has the message memorized. Oh, just stop. Stop. I don't know how this is relevant. I don't know what the case is about yet. All I know is you got a haircut.
A client my phone number. And I was completely taken aback. And it was like, hey, I'm sorry. I didn't mean to cross any lines. Genuinely, it's, I was just giving you my number. And, from there it was, I don't know what it was. I had continued, going and participating in the pinball league at the Coin Slot, which is a place that she had recommended when I, was getting my haircut. It's like, hey, I'm getting out doing stuff. What are some cool places? She recommended the Coin Slot. And it's like, cool. I got into pinball there. People from the pinball league in Traverse City invited me to join the league, which I did. And one of the individuals from that league,
make the bad man stop. Seriously. I played pinball and now I want some credit for it. Nothing to be proud of, Russ.
Had whatever issue with me, and I don't know what it was. I have genuine messages to the organizer of the league saying, hey, I don't know what this guy's issue is with me. I'm just trying to play pinball, get my life going. That individual started a rumor that I threatened him with a knife and that, I was a terrible person, that I'm just dangerous and this and that. And it's like, that has never happened. Genuinely, each time he had an issue with me, I would try to approach him like, hey man, I understand you got an issue with me. I'm not here to step on anybody's toes. I just want to play pinball. I heard from somebody within that pinball league that rumor had been spread not only to the league, but to other members of the community, including Alexis. And again, genuinely, the only thing I've been trying to do was say, hey, I'm not that person. I bumped into a few times while just living my life. I bumped into her at a Super Nuclear show where I did my best to make it obvious that I was just there for the show. At one point I was standing on one side of the room. I saw them come in, and during an intermission, they moved over to where I was initially standing. I moved to the other side of the room when I came back from that intermission just to be like, hey, I'm here for the show. I bumped into her again, Super Nuclear. I saw the posters at the Coin Slot as well as at a dispensary, White House. It's like, cool, I want to go check that out. Seems like it's right up my alley. I followed the artist on Instagram, and I found that he also does tattoos. And it's like, cool. They had a 15-year anniversary party. I was there sitting on the front lawn playing cards with people, and Miss Alexis showed up, and I did my best to be like, hey, I'm just here for this. And I was playing cards with people. I just don't want it to be awkward when I'm out doing stuff. And it's genuinely not that way at all. It was genuinely like, hey, if it seemed like I led you on, wasn't that way, fully, wholehearted, pure intentions. I was never, and that's it. Like, I'm just trying to live my life and get back on my feet after a really rough time. And I understand that, perception may be real, but I've genuinely just been trying to live my life. And it's one of those, like, all I've been trying to do is clear the air so it's not awkward when I bump into somebody someplace. And it's just like, I'm just trying to, like, actively live my life and enjoy life.
Okay. I was not prepared for this. I feel bad for him. It is awkward when he bumps into anybody.
The person that I communicated with in the pinball league is my quote unquote pinball mom. I was just playing pinball with her last night where she gave me a big hug and, told me about the Christmas present she bought me and super excited to give me. And it's one I talked to her about it where it's like, dude, I genuinely, she's like, me as a person at this point. It's like, all I've been trying to do is just make it so I can do things again. And I'm not trying to make anybody uncomfortable. I never have been.
We know what you were trying to do. And it was awkward. Demented and sad, but social. Still, you're creeping everybody out. Stop it.
All right. I'll ask you a couple of questions. Did she indicate to you that you were not to contact her any further?
Yes, she but that had been previously.
All right.
I had not. That had been before the previous PPO that was resolved. And after I had heard, hey, this guy not only spread the rumors here, but he also spread them around here about you being a terrible person, I only reached out and just said, hey, I genuinely, I never tried to meet up or anything like that. I genuinely reached out. My last message was along the lines of, hey, if you want to clear the air, that's cool. If not, no biggie. I've never had any hard feelings. And, all I'd want to do is clear the air. I still think you're an awesome person.
Hold on.
Of course.
Why would you do that if she had made it clear to you that she did not want to have contact with you?
Unfortunately, it's due to the fact that I hold her in a high enough respect that I understand that situation was a misunderstanding. And I hold her in a high enough respect that it's like, hey, I please just wanted to at least clear the air, say, hey, man, I'm not that person.
All right.
And it was
that you want me to know.
Of course, I've never. It says in there that I've tried to find. It's like I've never tried to find out where she lives ever. Like on my military service, on my life, like I go to pinball and I come home, and I go to my VA appointments and I come home. I've never, you can probably use the geolocation on my phone to confirm. Like I've never, intentionally tried to ever find out where she lives or drive by or anything like that.
I may come back to you. Okay, hold tight.
No problem.
Ms. McCune. Thank you. Ms. McCunick, I'd be glad to hear from you. Is there anything you'd like me to know at this point?
Yeah, so I cut Zach's hair last on the 27th. I then banned him from the shop on the 14th of October in 2025.
Back on the 27th. When was that? 27th, which month?
Of 2024 of September.
All right. Keep going.
I banned him from Jude's Barbershop on October 14th of 2024. He then found my coworkers on social media and me on social media trying to contact me. I told him to leave me alone. He then left me voicemails, 3 in February. There were 4 voice.
All right, this is where I give the ladies a hard time sometimes, but this is the crap that I actually feel sorry for them for. When you have these dysregulated guys, it sucks. It sucks. I understand it, ladies. I do. She said, and I believe her, I told him to leave me alone. That's the end of all future discussions. Period. End of statement. That's it.
In February, 2 in April, and 2 voicemails in May. I did not respond to any of them. And I had told him multiple times to stop contacting me, and he continued to over the past year. The last voicemail was on the 25th of October this year, and then he sent me a text message on October 31st of 2025.
Now, the personal protection order was in effect as of when?
It was signed by you on the 28th of October, but it was not physically served to him until the...
I think some Andrew tutoring will fix this whole situation right up. That's a fantastic idea.
31st.
In all
of
seriousness,
October.
it would help.
All right, the same day that you received that text message.
Yes, I went to the sheriff's office as soon as I got it, and I wanted to figure out if it had been served to him because I had just got it signed. So, yeah.
Okay, I interrupted you. Go ahead and continue.
And that was the last contact that I have recorded is on the 31st. So that's it.
Okay. And this continued contact, how does it make you feel?
Unsafe. I've had people reach out to me, and anyone that he has come in contact with that I know has warned me about him. They've also observed like obsessive behaviors. And it makes me feel unsafe. It makes the people at the tattoo shop feel.
Yeah, we've observed obsessive behaviors right here in court. Yeah, we believe you.
Unsafe. It makes my coworkers feel unsafe, and we just want him to. I just want him to leave me alone.
All right, thank you, ma'am. Mr. Wilkins, I'll give you an opportunity to respond if you have anything else that you want to tell me.
Of course. Well, in regards to the I was not served the paperwork before that message was sent. I didn't get that paperwork until like.
When you make a woman with a neck tat and a septum piercing look like the adult in the room, you have failed. Plain and simple.
5:30 p.m. that night. And I would have never, reached out had I been served that paperwork prior. Again, the only reason I reached out was to clear up, hey, I heard that rumor was spread by that individual. And again, the reason that rumor was spread by that individual is because at the coin slot, there were on numerous occasions where he was drinking and okaying the service of alcohol to an underage individual who I only knew was underage because he happened to live directly across the hall from me. And when I said, hey, man, at first it was like, oh, shit, I'm sorry for the language. At first, I didn't know that they were under the age of 21. And it was like, okay, cool. If you guys want to get a beer sometime, let me know. And then it was like, oh, yeah, we only go there on this day on Wednesdays because this bartender doesn't ID us. We're under 21. And after, going to the coin slot for numerous times, I realized who the bartender was on those days, as well as who was working on those days, and who that underage individual was drinking with numerous times.
All right, hold on.
And that individual's...
Hold on.
Yes, sir.
All right. You're going into areas that aren't directly relevant to...
Well, it is unfortunately directly relevant to the case, sir, due to the fact because that individual is the...
Hold on. See, I don't wear this because I enjoy the look. All right. You have to actually wait for me to call on you. And if I tell you to stop, you need to stop. Okay.
Of course.
All right. This whole route that you're going with regard to the episode at the coin slot involving someone who was drinking underage, that doesn't mean anything to me. What I'm concerned about is frankly the context that you had over a period of time with Ms. McCunick after the point that she made it very clear to you that you were banned from the shop and that you were not to contact her. And I'm absolutely ready to rule. So the issue before the court today, hold on. The issue before the court today is a personal protection order that was issued to the benefit of Ms. McCunick, the petitioner, as against Mr. Wilkins. That personal protection order was issued on an ex parte basis, that means by the judge, pre-hearing. It was issued because I was convinced, based on reviewing the petition, that there were sufficient episodes of contact, unconsented contact, that were sufficiently harassing to constitute stalking. And as a result, that the petitioner was entitled to ex parte protection. Today, we've heard from Mr. Wilkins. We've heard from Ms. McCunick. Mr. Wilkins was under oath. He would like the order set aside. There's a lot to be impressed about with Mr. Wilkins. He's a veteran. He's working to reorganize his life after his service. He's been communicating with a congressman in order to help get a direction with regard to his care, which is how he came into contact initially with Ms. McCunick, because he needed a haircut. For that meeting, he interpreted his contact with her at that time as an invitation to continue contact, perhaps develop a relationship. He was mistaken. She made it clear to him that that's not what she was interested in. The contacts continued, and she ultimately banned him from her place of business. These contacts began occurring on or about September 27 of 2024. He was banned from her place of business October 14. He continued to contact through social media on multiple occasions following this excommunication from her office, or the notice of trespass, etc. Frankly, the respondent just simply isn't taking no for an answer here. The petitioner has made it absolutely clear she wants no contact. She wants no explanation.
If I may speak on my own behalf, sir.
You're going to be muted. You may be muted here if you continue to speak. The time for the hearing, hold on. This isn't tiddlywinks. You're in court. You only speak when you're called on. Do you understand?
I understand, sir. I just haven't been given an opportunity to actually.
Hold on. Then stop. You're only making things worse for yourself, believe me. These contacts, as I said, have continued. The respondent has simply not taken no for an answer, and has continued to try to resolve the situation to his satisfaction. In doing so, he has created a level of fear in Ms. McCunick and the people that she works with that I think is reasonable and rational. And I'm not going to make a ruling on the issue relating to communications involving his use of a knife or not. There's not enough information for me to make that call. All I need to do, frankly, is determine that Ms. McCunick feels harassed based on multiple unconsented contacts, which clearly have occurred in this case. So as a result, the personal protection order is properly issued, and it's going to continue. The motion from the respondent to terminate the personal protection order is denied. The order remains in place. Mr. Wilkins, do not have any communication yourself or through any third parties by social media or otherwise with Ms. McCunick. Do you understand, sir?
Yes, sir. And as I was attempting to say earlier, I never sought out her social media in any way, shape, or form.
I found
the only.
All right. So
the only time it ever popped up was in my suggested friends, sir. So again, I have no interest in contacting. The only thing I was attempting to do has been clear.
This is going to be easy for you then.
Oh, of course.
All right. I don't know if you, thank you for your service in the military. The military has a rank system. You're entitled to, you're required to provide respect to people that have a higher rank. The same application applies in court. All right. Whether you agree with my decision or not, you're required to show respect here in court. You are in court. So hold on. So that means you don't speak unless I allow you to speak. That's how it works. Okay. It's not personal. It's just how the system works. I suggest to you in the future that if you have to come to court, you bear that in mind or you expose yourself to contempt of court. Any violation of this personal protection order will likely result in a contempt of court citation. That's a 93-day misdemeanor. It could subject you to a fine of up to $7,500. So it's a serious matter. Please take it seriously. All right, Ms. McCunick, do you have any additional questions at this time?
No, I do not.
All right. Thank you both. Take care.
Thank you.
You as well.
There you have it. I thought that was really well handled by the judge. The decision was obvious. He did that. He was stern but gentle with the guy at the same time, which is what is called for. I actually feel sorry for this guy. A lot of the people on here that I really go after and laugh at, it's when they are a-holes, they know they're being a-holes, and they do it anyway. That kind of opens the door. This guy was wrong, but is so low functioning, he does not realize it. He does not realize how he's coming off. I don't think he's trying to be bad. He needs some help. I hope he gets it. If he doesn't, he's going to end up in more scrapes like this and basically end up in jail. But in his heart, he thinks he's a victim. Not in a mean way. He really does. He's like, I'm really trying to be nice. He just doesn't. He doesn't know how to socialize. I mean, he's got no, I don't know, emotional intelligence or whatever the hell you'd say. I don't know. He's just awkward. And someone needs to help him, but I don't know. I don't know if that's because he's got some issues or whatever. That's not my area of specialty. But it's kind of sad to see. And I thought the judge handled it very well, which was sort of maintaining some respect for him and being nice to him while being very stern and explaining the situation. Good times, good times. We start with Laura and we end with that kook. Thank y'all for coming on. I appreciate it. I'll see you soon.